Uh, are you able to hear me?
Yes, clearly.
Okay. Okay. Uh, so thanks a lot, Ishana, and I also thank Jindal Global Law School for giving this opportunity to present this paper. Now, as far as this paper is concerned, it's very it says a disputed or treatment of disputed claims in CIRP. In insolvency proceedings, and I will talk about how jurisprudence has evolved in last 5 years over this issue. Now, essentially, I have lived through this narrative throughout the insolvency of SR Steel on account of the sheer large number of claims, disputed claims, varied type of creditors, and it was highly litigious account insolvency process which went up to Supreme Court, Apex Court twice, and almost 100 days of litigation, and I will say continuous hearings, almost day-to-day hearings in NCLT, NCLAT, and Supreme Court. This is what is, and I will, and I, fully believe that enormous jurisprudence has evolved around this subject, and which has given a lot of clarity to the creditors, to the role played by the resolution professional, to the various resolution applicants, while how they will have to treat the various claims in the resolution plan which they are submitting. So with that, this is the background, and I thought, this working paper, the narrative, the theory, and how, some of the international jurisprudence has been used, and some of the unique features which has been arrived at, through this jurisprudence, which is completely unique to India. So I will bring out in next few minutes. So as we know, in any insolvency, creditors play a major role and are the major beneficiary in any insolvency proceedings. And during insolvency, particularly, I'm talking here of corporate insolvency resolution process. I'm not talking, this does not cover liquidation, this does not cover pre-pack, only the corporate insolvency resolution process. An IP verifies and consolidates the claims which are received subsequent to the public announcement of insolvency. So whatever claims in various forms and from various types of creditors are received, so those claims are collated and verified by the resolution professional, and essentially from this process, what really comes out is the RP forms a committee of creditors. Okay, he decides which creditors would be forming the committee of creditors. So it's essentially the financial creditors, and here in under IBC, all financial creditor essentially constitute committee of creditor. So the first part is the forming the committee of creditor, and once committee of creditor is formed, then they are the one who are the real decision maker in terms of the eligibility criteria or the approval of the resolution plan. So essentially, this process of claim collation and verification is very important, because if this process is delayed or not really done in a fair manner, so the litigations around it can be protected, and it can delay the entire resolution process. And as we know, once the resolution process is completely, or resolution plan is approved, then it is submitted to the adjudicating authority, which approves it, and any creditor which has got a grievance, they can approach adjudicating authority, and adjudicating authority has to essentially adjudicate or decide on those grievances of any creditor. So in part one of the paper, I have it addresses the process of claim filing by creditors, definition of claim, which is very wide. Financial creditor, operational creditor, definition. This was completely different mindset, which lenders and various stakeholders had to adopt, because we did not have the operational creditor as a separate class, and we are now, this is the last session, and you have gone through the sessions, so now the higher threshold of proof of claim for initiating insolvency by an operational creditor. So that kind of a distinction is there between financial creditor and operational creditor, which we have also seen in real estate session, insolvency. And essentially, so as I've decided, as I have made a submission that based on the verification and consolidation of the claims, essentially the composition of a committee of creditors is made. The definitions of claim debt are very, very wide at it, and it encompasses various laws. And when RP receives the claims, definition is it will cover all kind of claims, whether it is a litigated for a number of years, if we have pending in arbitration, in various courts, in various appellate, or under appeal. So the various kind of disputed claims will be filed. So essentially, if we look at how the jurisprudence or has evolved around it, so I will say, if we look at if there is any disputed, and disputed means, as I told you, any dispute, any claim under arbitration, appellate, lying in various courts, that is to be treated as disputed, essentially. And at the time of initial, regulations which were introduced, as per Regulation 14(1) of CIRP, it was essentially, stated that, if any claim is not precise, and due to any reason, now such kind of claims are to be estimated. Best RP has to make the best estimate of such claims. Now, I am telling from the practical example, that when a disputed claim is received, which is pending in various court, and at the same time there is a moratorium which starts from the initiation of insolvency proceeding. So those proceedings, legal proceedings, cannot continue. So those legal proceedings get suspended, and thereafter, if RP has to make the best estimate, that means RP is a sort of adjudicating, so that becomes the adjudicating function. However, the Supreme Court judgment in Swiss Ribbon, that came to the rescue, and Supreme Court made it very clear the role of RP is a sort of facilitator, and RP is not a quasi-judicial person, unlike a liquidator. So essentially, the RP does not adjudicate or based on that make best estimate. So that was a really an issue, which was being faced, by me as RP, that how to decide. This is a humongous amount of disputed claims. Okay, and the admitted claims. Operational creditors was say X 5,000 crore, and disputed claims were total claims were 3.8x. Okay, so that was the difference, and which were to be decided, and these were all very high profile creditors, and who will go to the court if their issues are not addressed. So first, as I said, yes, Supreme Court in Swiss ribbon case decided that RP does not have quasi judicial function. So they cannot decide on the quantum of the disputed claims. So there is no best estimate to be made. So under that circumstances, I had to find a solution, and so the solution. So I had to look at the precedents which were available internationally. So one is, I saw that unilateral legislative guide on insolvency, and which provided for a disputed claim, to be admitted provisionally at a notional value. And similarly, secondly, I saw refer to precedents in common law jurisdiction, such as UK and Australia, which also in certain cases had provided for ascribing value of disputed claim at $1. So this was something which came in handy, because by this I could admit these disputed claims at a provisional value, and secondly, by admitting them and including their litigation in the information memorandum, they could participate in the insolvency proceedings. So they are not out of the proceedings. So their completely facts are available with anybody, who has to take a decision. And there is no, adjudication or crystallization of dues being done during this period, because anyway, there is a moratorium. And secondly, during CIRP process, insolvency process, this dues cannot, the legal proceeding get suspended, and there cannot be any crystallization. So that was one, that about the ascribing provisional or the nominal value of $1 or rupee 1. So this also had a very interesting turn of events from one court to another, as it moved from NCLT to NCLAT and then Supreme Court. So just to mention here that NCLT did not give any. Obviously, if a matter is pending in Supreme Court, then NCLT is obviously also not going to adjudicate on those issues. So they also did not, all these creditors felt that NCLT should adjudicate, but it is really not domain of NCLT to adjudicate on those issues. Okay, on those disputed claims. So they left it at that, and so they also agreed with the view which RP had held, that treating them at a notional value. However, when this was appealed in NCLAT by major creditors, and what NCLAT in its own wisdom, they admitted these entire disputed claims. Okay, so look at the operational creditors, which were admitted at 5,000 crore, okay, in one go, it became 19,000 crore. Okay, so X became 3.8X. Yes, okay. So, so this is what happened, and then finally the matter landed up in Supreme Court, Apex Court, and where the Supreme Court upheld the practice of admission of disputed claims at a notional value of rupee 1, and then they reverted the operational creditor dues to X, that is 5,000 crore. So this is how it evolved over a period of time. The judgment of SR Steel is also very important, from two other angles. Second, so first I mentioned, practice of admission of disputed claims at a notional value of rupee 1. Secondly, claims received after approval of resolution plan by COC were rejected. As we know, there is, even though there is a time period for creditors to submit the claims, okay, within certain time period. However, creditors, continue to file it, till the last date of approval. So as a practice, yes, RPs have been accepting the claims and admitting, decided, but it becomes never-ending process. So Supreme Court clearly said that claim received after approval of resolution plan by COC are to be rejected. So they won't be considered. So I think that was a finality to that. Here, one other aspect which I would like to mention, that sometimes the creditors come and say, they have not participated in the process, or they could not file claim because they were not aware of the insolvency process, and RP should have given a sort of notice to them. The court in Jyoti structure particularly has held that there is no notice to be given by RP separately to each creditor, and public announcement is something which is handled, and nothing beyond that. That notices are to be served on creditor to file their claim. So second was the claim received after approval of resolution plan. So that was the Supreme Court what they held, and most importantly, we'll say, and which is completely unique to IBC in India, is that claims which are not covered in the resolution plan are extinguished, and thus providing a clean slate to the new resolution applicant who is coming in. So the claims which are dealt with in the resolution plan, so which are not filed, are completely extinguished. And this led to the doctrine of clean slate. And this was a major breather for resolution applicants, potential resolution applicants, because they clearly saw that protracted litigation subsequent to the approval of resolution plan, at least that would be limited. So the and this is something most of the resolution applicants are very happy about, the doctrine of clean slate. Subsequently, this doctrine of clean slate was tested in two accounts, and two creditors had challenged in two different high courts, and who gave different views on this clean slate aspect also. Subsequently, again, Supreme Court dealt with these similar issues in Ghanshyam Mishra case, and which reiterated the clean slate principle, which is the clean slate principle, and it clarified position that no disputes which are part of a resolution plan or claims which are not filed or which we have not participated in the resolution plan, they cannot agitate in future. And I think that settled the issue. I think after it was clear earlier also. However, there was certain confusion or I will say some interpretational issue. So that has also been settled by Supreme Court in Ghanshyam Mishra case, and so this issue is clearly more or less now settled as far as the creditors' claim, disputed claims are concerned. Now, to strengthen the further this clean slate principle, amendment to section 31(1) was also introduced, which again reiterated from the government, okay, that statutory dues essentially, and the government or the state dues, they are lower in priority, and that is there in the statement of object and reasons also, which where it makes it very clear that the prior and section 53 of the code, the priority of dues of the central and state government is lower in priority. So I think the government has not really wavered in that aspect. Okay, and 32A, introduction of 32A, which specifically extinguish the criminal liability of the corporate debtor. So that is also strengthens the clean slate principle and overriding power of IBC. So I will say that in the end, in short period of 5 years, there is a significant evolution and concrete jurisprudence which has emerged with respect to disputed claims, admission, treatment, claims not filed during CIRP, question of continuance of proceeding under section 60 subsection C after resolution plan is approved, so etc. Is now has its finality. Okay, and doctrine of clean slate is definitely unique, and however, I will say here that in under present position, question before disputed claimants, okay, or the operational creditors which have these disputes going on for a number of years, they face the question of is now the evaluation of these protected legal proceedings and whether any benefit is getting accrued or they should settle, okay, or otherwise in future if there is any insolvency, they may get very little or they may not have their participation fully, or they may not get paid. So with this so over to Shana.
Thank you so much, Satish. That was quite excellent, but let's hear from the discussants and see what they have to say. We start with Robert.
So what I can contribute, firstly, of course, thanks a lot for having me. The second time already that I can contribute to JGILS Global University. Thanks a lot, Ishana. When I read the paper, it was both very interesting and very strange because our system is quite different in Germany and in Europe. And what I can contribute now is to give you an overview and rush you through what our system more or less is in Germany and in Europe. Now in order, okay, let's start here. I have to start maybe, which is very easy to understand for Europeans, but maybe not so easy for Indians. We have 27 countries and different jurisdictions and different insolvency systems in Europe. without the United Kingdom, which after Brexit is not a part anymore. And this creates a lot of problems, and this creates, of course, a lot of differences between the systems. What I'm going to show you now is the German system, which is quite easy to understand, I think, and is kind of an example maybe how insolvency proceedings can go. The unique feature of the German system is that you have one uniform insolvency proceeding. You don't have different proceedings for restructuring or liquidation. It is decided within the proceeding what happens. And just to rush you through the proceeding very briefly, you have an application for the proceeding, then you may have securitization measures in a provisional insolvency proceeding, then you have the insolvency proceeding with a potential insolvency plan proceeding, which can be restructuring plan, but not necessarily. It can also be liquidation. Both proceedings can go to liquidation or restructuring. And then for individuals, even individuals as merchants, not necessarily consumers, they have the possibility to receive a discharge at the end of now it's a 3-year period as a whole, starting from opening of the proceeding. As for the court involvement, the court doesn't have much to decide in German insolvency proceedings, except for appointing the insolvency practitioners. And so the judge is responsible in the preliminary proceeding, where you have securitization measures and stuff to take. But after that, he's only in charge in an insolvency plan proceeding. And apart from that, it's a registrar of the court. Because what the insolvency court does is more or less just record what's happening and well, take an eye on everything happening correctly in a formal sense, but the court doesn't make any material decisions within the proceeding. You can have that kind of proceeding both in a regular proceeding with an insolvency administrator and in self-administration of the debtor. So it's a debtor in possession proceeding, and then you can have that preliminary self-administration, which sometimes is called a safeguard proceeding, and that's a special feature. And what the court does, already mentioned it, the court appoints the practitioners, which are the administrators in the regular proceeding, provisional and final administrator, and a custodian, which is kind of a watchdog in the self-administration proceeding. Now to come to treatment of claims. Regularly, what always happens is that the court will determine a deadline for the filing of claims, which in Germany is not an exclusive deadline. You can file your claims all through the proceeding until the end. In other countries in Europe, it's different. You have exclusive file date. If you are filing, then well, you can drop your claim into the rubbish bin. The court also defines a date for the verification of claims, which can be a hearing in court, which can also be in the written proceedings, just a fixed date where the claims are verified. In Germany, regularly, the administrator has the task to inform all known creditors, and the court will publish opening of insolvency proceedings under that address in the internet, which I stated here, and will also invite the creditors not only to file their claims, but also to announce the securities they claim. There are special EU provisions for the claim filings, and that is that every member state creditor should receive a special filing invitation in different languages and special filing form, which I must say is rather confusing. It's easier to use the administrator's form, but you're obliged to do that. And then there is a minimum filing deadline of 30 days for foreign creditors from other EU member states. And all EU member state creditors have the right to file their claims in any official language of the European Union. So the filing process in Germany looks like that. the creditors file their claims with the insolvency administrators or with the custodian in self-administration. And then the administrator prepares a table of the claims, and he deposits that table together with the filing documents with the courts. Now, the colors in my picture, they have a meaning. The blue around the red square here is that within the court, the filings are deposited so that every participant can go to the court and look at all those filings. And then you have the verification date. And in that verification date, the court inserts into the table the result of the hearing, which can be that the claim is contested, it's a disputed claim then, or the claim is not contested. And if the claim is disputed by any other participant, then it's up to the creditor and that disputing party to resolve that in a regular litigation. And after that, having the disputed claim sorted out or not, you have a final claim, a final table of the claims for the distribution, and then you have the distribution process. Let me add that it's more or less the same when you have an insolvency plan proceeding. The filing process and the verification process is totally identical. And within the insolvency plan, you can have a different distribution regulation, but it more or less is aligned to the distribution process in the regular proceeding, because no creditor can be put worse in an insolvency plan than he would be within the regular proceeding. And so to come to the regular distribution process, the distribution is announced publicly, and then there is a period of 16 days starting from the announcement for creditors with disputed claims to prove to the court and to the administrator that they initiated a lawsuit or they already received a judgment for their claim that it's a valid claim. If they don't meet that line, then they will not get into the final table for the distribution. If they come up with the proof that they have initiated a litigation, then the table for the distribution is amended. And after that, if there is an amendment, or if there is a lawsuit over a disputed claim, the administrator makes a reserve until the end of the lawsuit, and the rest of the money is distributed. And if the litigation turns out that the disputed claim is valid, then the creditor receives his quota. And if it turns out that it's not valid, there's a delayed distribution to the other creditors. Now you also have, which is not on that picture here, you also have a regulation in an insolvency plan proceeding for creditors who didn't participate in the proceeding, who didn't file their claim within the insolvency proceeding. And that is a regulation that after 1 year, after the confirmation of the plan, any claim which arised prior to opening of the proceeding is timed out, cannot be claimed anymore. So it's a time-barred claim which the debtor hasn't to pay anymore. But if the creditor comes within that 1 year after the confirmation of the plan, then he is entitled to receive the same quota that he would have received if he had participated in the plan proceeding. So this is more or less the German system, which is, I would say, with regard to the filing process and the distribution process, kind of the same in most of the other EU jurisdictions. And that's so far for me. Just one more remark. I asked Ishana to make that picture available to anyone who wants to have it, because it's quite confusing if you have it as a whole like this. So thank you.
Thanks a lot, Robert. Now we move on to Debanshu for his thoughts on the paper.
Thanks, Ishana. Thanks, Satish and Robert. Just give me a second. I have a couple of slides to share. Okay. Yeah. So so broadly, I agree with Robert. It seems like a very comprehensive paper, covers the evolution of the law very well. So congratulations to the authors. Just my comments would largely be limited to the policy background, because that's where we contributed. So I just wanted to say that a lot of people have said that our law is very uniquely designed, and that's largely because all our previous laws were largely copy pasted from other jurisdictions without much contextualization, and that they proved to be big, huge disasters. And therefore, this law is tailor-made for the Indian situation, and that's why a lot of things seem unique, or also possibly also unfair on the face of it. But there are justifications for all of that. And as far as disputed claims are concerned, if we divide it into three parts: the admission process, the claims collection process, and the post-plan approval process. So the disputed claims are relevant for all three parts. And as far as the admission process itself is concerned, the pre-IBC system, the liquidation regime that existed before the IBC, it was almost impossible for a creditor to have its case admitted in a court, because it was very, very easy for the debtor to dispute the claim. Like, it was very, very easy. And therefore, when the law was being designed, there was this intentional effort to make sure that it should not be so easy for the debtor to dispute a claim, and therefore kind of obviate or thwart the proceedings. And therefore, originally, the law actually said that for an operation for the debtor to be able to establish that there was a dispute, he should be able to prove that there was a pre-existing litigation in relation to that dispute. That was the original position of the law, and I think that's the case in Germany, as Robert kind of pointed out, that there should be an existing suit or proceeding in relation to it for a dispute to prove its existence. But the Supreme Court kind of watered it down and said that no, that's a very high threshold, very difficult for the debtor to kind of meet in most cases, and therefore it watered it down, and the law was then subsequently amended. So although we kind of started from very high threshold where it was very difficult for the debtor to dispute, today as we speak, it's very easy, at the admission stage to dispute the proceeding, especially for the debtor, and therefore we also see a lot of delays because of this. I briefly want to talk about the concept of IUs here. Originally, when the law was enacted, there was this expectation that information utilities, which is an entity that's kind of supposed to have all the data in relation to the financial or an operational debt of any given corporate debtor. Since all this data will be readily available, it will be there'll be very little reason for anybody to dispute claims, etc., and proceedings will run very efficiently. But unfortunately, that industry has not taken off at all. Although we do have a large IU and there is a lot of data in that IU, you still have other forms of proof that are admissible for proving the existence of a claim, and therefore IUs are still not the go-to kind of infrastructure for getting a case admitted, and therefore the industry hasn't really taken off. We can discuss pros and cons of this, and the way forward for making sure that IUs get better integrated into the system, during the course of our discussion. But so far, it hasn't taken off at all. Now, if you look at the second stage, which is the CIRP, the process, the second part of the process. So here again, there is a very objective process, a separate process for financial creditors and a separate one for operational creditors to file claims. And again, there was a lot amount of, before the IBC was designed, we had this advantage of looking at the history of frivolous claims under the liquidation regime, where it was rampant. Like, people used to file frivolous claims in almost every case, and not just frivolous claims, claims with no basis whatsoever, fake claims, so to speak. And therefore, when the claims collection process was being designed, it kind of had a very unique feature, where in addition to the face value of the claims, the insolvency professional was required to verify the veracity of the claims from the books of the corporate debtor. So it's actually a statutory requirement. So therefore, a double check, so to speak, and that's because of the history, because it was you had these frivolous claims that used to be filed as part of the liquidation process. Now, as Satish pointed out, if a claim is disputed, typically the practice is to accept it at notional value. But I also understand that in a lot of cases, while this notional value is useful in the beginning, where at least that guy kind of gets a seat in the COC if it's a financial creditor, because his name gets registered. In a lot of cases, there is commercial settlement that takes place as part of the resolution plan. So while it might be 1 rupee at the time of acceptance of the claim, but in the plan, he might still get treated better. Maybe Satish may want to respond to that during the course of the discussion, but I understand that a lot of this happens. And maybe this is a market-driven solution to this problem of the system kind of now being heavily loaded in favor of the non-disputing party. So here there is some safeguard that if the committee of creditors determines that a creditor who's disputing or who has a disputed claim is really, really useful for the business going forward, then let's commercially settle with him as part of the resolution plan. So a lot of that is happening despite this admission at notional value. So maybe Satish can talk about it during the course of our discussions. And again, lastly, IUs, could have been relevant here also, like during the claims collection process, claims could have been filed through information utilities, but this piece also remains completely underutilized. Like I understand that both for financial claims and operational claims, this isn't really used much in practice, that is using IUs for this purpose. Then lastly, Satish talked about the clean slate theory and the fact that, once a plan is approved, it should be binding on everyone. Here, I just want to give a brief background. When Section 31 was being drafted, the government was aware that, we don't want a situation where after a plan is approved, you have other claimants coming back and asking for more than what was given to them as part of a resolution plan. Because this used to happen a lot under the previous system, especially under the Sikh Industrial Companies Act, where there was a lot of litigation after approval of a plan. So the government, if you look at the original language of Section 31, it said that the plan shall be binding on all relevant stakeholders involved in the resolution plan. It was a very broad wording. And the intent was very clear that, even tax authorities and other kind of claimants were supposed to be bound by this. But as Satish kind of pointed out, they kept filing their claims despite this provision, which kind of said that the plan is binding on everyone, you really can't come. But they kept coming back and asking for their claims. And then the Supreme Court and SR kind of clarified that you can't do that. And then, subsequent cases have also done that. And now the law has been amended specifically to say that the plan is binding on everyone, including statutory authorities, tax authorities, etc. And I just want to mention briefly here that, when the law was being designed, the government was aware that the folks who have the maximum exposure to non-performing assets and who need to recover are large public sector banks. That's also public money. So you need to balance that interest with the interest of tax authorities who are also collecting public money. But so then the government took this call that, in this law, it'll be, we'll give, a higher position to financial creditors, most of whom are big public sector banks, and the tax authorities and government will come below. And therefore, and that's the logic that needs to be respected. And thankfully, that's now been clarified with this latest amendment, where I think the clean slate theory has been given a specific statutory recognition. But my question to Satish is, has it really helped? Because from my conversations with lots of people, I understand that these authorities still keep coming. They still keep coming despite these amendments and despite these rulings, and they keep, asking for their dues after a plan is approved. And here I also want to briefly mention that this is not a new issue. This issue was alive even in 2008, where one of our old committees on financial sector reforms in 2008 had recommended that, in the context of old bankruptcy law, that authorities should go and recover their dues when the business is doing well. Once a business is insolvent and it's in the insolvency proceedings, they should know where they stand in the scheme of things, in the hierarchy of priorities, and take what and do whatever they can ex ante, and not wait for insolvency proceedings to conclude and then go and ask for their claims. But it's been 12-13 years since that observation, and I think at least practically not much seems to have changed. And lastly, we can again discuss it as part of our subsequent discussion. Is the current system on disputed claims fair to all stakeholders? My assessment is that I think the admission process is broadly fair, although it's fairly easy for the debtor to dispute claims. There are kind of safeguards in place, and at least the Supreme Court has said that it has to be genuine debt, etc., and a genuine dispute for the debtor to be able to dispute it. And it's much better in comparison to the situation in the past, where everything was disputed and there was no movement whatsoever. And then as far as the CIRP process is concerned, I think that process works really well. And thanks to the insolvency professionals who've kind of done this part of their role very well, where the entire ecosystem has a lot of confidence in an IP's ability to run the claims collection process efficiently, and so the entire ecosystem kind of trusts the IP to do this effectively, and I think that's reasonable. That's worked really well. But the only problem is if someone's claims gets accepted at notional value, and he had a very legitimate claim, then is it fair to then say that because of clean slate theory you are gone? Whatever, if the plan gives you notional value, then we are sorry, that's the best that can be done. Like, is this outcome fair for the creditor in question? And so and I think the clean slate theory broadly is fair, and especially in the interest of efficiency. But what about genuine disputes? Like, if it's a really genuine dispute, at least in German law, as Robert indicated, you have a period of 1 year within which you can come back and claim something. But is our system a bit too oriented in favor of efficiency and a bit unfair, so to speak? Yeah, so that's all I have to say. Stop sharing.
Thank you for that response, Debanshu. I'm going to first allow Satish to respond to both Robert and Debanshu's comments, and then ask a question and throw it open to the panel to close out the ceremony, and then invite our executive team. Go over to you, Satish.
Okay. Okay. Thanks. So very, very insightful, Robert. You give the German insolvency process, and Debanshu, for giving us how this laws were drafted, and what was the thinking behind while these laws were being enacted. So the couple of points which you have raised, Debanshu, one is that yes, these authorities keep coming back, even after resolution plan has been approved by adjudicating authority, or it has gone through that level. Yes, I think it's a learning process. And as you know, these central government and state government authorities, there are it is not one single authority, like GST or service tax. Okay, so there is not one authority. Okay, it is in a one particular state also there may be 20-30 authorities which may issue the notice, which may file the claim. So not all of them are so much the familiar, or even if familiar, they make last attempt, just to file, and so that they are not asked tomorrow that why this has been given up. But I think from what I understand, and if you go through the annual accounts of the companies whose resolution plans were approved 1 year or 2 year back, okay, and how they have reflected those claims which have been extinguished, and these have been accepted, finally, whether it is the excise duty, service tax, GST, or some other, some other taxes. So finally, it has been accepted. And a lot goes to, because these authorities have also filed, they keep on going to various authorities, and and now we have enough number of precedents which are quoted to them, and then now, and some courts have also said that, and it's a sort of frivolous, and that you keep on coming to us. So that is one thing. Other is that regulators also, I think they are doing a lot of programs and advocacy, and to apprise them that, okay, what are essentially the rights, and in terms of the filing of the claim at the right time, and then what will be the impact. So a lot of time, they think that they are statutory bodies, so they don't have to file also, claims. So so last month also I got a call from one of the the one of custom that I have to file the claim. I said, thank you, sorry, it cannot be done. So but if you look at yes, on how the annual accounts, and I think this has been accepted, and mostly now it is settled. And if I'm sure if any issue goes to any court, or high court or Supreme Court now with this Ghanshyam Mishra, then issue is settled. So that is one thing. Other is how these disputed claims are really dealt with in the resolution plan, and how COC will look at from the commercial wisdom point of view. Yes. One is first of all, these disputes or litigations are disclosed in the information memorandum. Resolution applicant has to assess, what sort of litigation is it. So they would like to settle it, they would like to continue, get it crystallized, and then pay off, or they want to extinguish. So that is the first step. And it is also possible that sometime some of the creditor, these disputed credit, like mentioned, it can be genuine also, and so resolution applicant may like to have a relationship, so kind of giving a differential treatment to that particular creditor. And once a resolution applicant proposes that, and then it is for the COC to approve that in its wisdom, because that is going to be in the interest of the maintaining going concern and maximizing the value. So that also has happened in one particular case, as I mentioned in the paper, GCG infrastructure, where the plan clearly mentioned that litigation will continue post approval of the resolution plan, and once liability gets crystallized, it will be paid at the same percentage as that particular class was paid. So yes, it will vary from case to case. It can be some creditor who is very essential to the operations. So I think the differential treatment can be made. Fairness of genuine disputes, yes, I think that is the question I have raised in my paper. Genuine disputes which are going on for last so many years from one forum to another forum, okay, then it goes on. I think now it is for the creditors to decide that if the financial health of the corporate debtor is deteriorating, whether it is going to be useful to have long protracted litigations. I think this is also a lesson for the these some of the creditors to really stop at certain point of time, maybe if there is a solution emerging. I think this is what it is, that the protected litigation also is not going to help you, and that relation of the that sort of settlement or mediation will definitely, these creditors would definitely look at. So
thank you so much for those remarks, Satish. Just as a closing, because the reason why this panel was kept as the fourth paper and the last paper for discussion was also to sort of do a wind up of the discussions that have happened, because the underlying theme is about parallel, or what happens in the case of a dispute. And while a lot of the inquiries have been answered by this panel, I want to just identify 3 points as closing in terms of the sessions, and go around the table for one final comment before we close the event. The first very just now thought that has occurred to me is about cross-border and what happens when we actually get into the issue of cross-border disputes and foreign creditors who qualify as perhaps operational creditors, who are basically getting into a disputed debt situation, right? I remember the first lecture which Robert ever did was actually about a German-French cross-border dispute, and we don't have that amount of merriment with any country, I think, when it comes to treatment of disputed debt, right? And that leads to the question of enforcement and enforcement-related concerns, because we're not very high up on enforcement of any kind of litigious proceeding. The second thing that I find very interesting, and I think is the next step, which comes from the past 2 panels, is about consumer bankruptcy as the next step. Right? We've seen disputed debt in a very specific, through a very specific lens of operational creditors in big 12 insolvencies. But now that the insolvency code has come back into force, we are looking at consumers who will become a part of the bankruptcy process, who are in the form of retailers. An example was, say, in the aviation sector, a case that is presently pending about refunds at the time of COVID. And you are looking at consumers who are very much part of the insolvency process, because those refunds are of a very high value and a very high amount. So you're looking at consumer bankruptcies also becoming a part of disputed debt. And we really don't know how we are going to treat them at the initiation stage, perhaps, because we know what the qualification threshold is, but they might qualify as class of creditor. And at a claims verification stage, that's why I think it might become tricky. And we don't really have a step chart just yet in terms of what is it that you are going to be treating as a part or accepting as a part of claims, at what value, because the notional value may not work for a foreign operational creditor who might have a genuine claim, as Debanshu put it. So I only have these 2 comments as opposed to questions, and I just wanted to go around the table for a viewpoint, starting with you, Satish, then Debanshu from the India-like perspective, and then closing with Robert from like a global view, and close out this panel, please.
Right. So, so coming to the points which you have raised, I think, when we are looking at the insolvency in India, I think the codes are, or how these, issues are being dealt with, is the one is, one is not going to admit insolvency if it is, say, COVID related, or just, the courts are also, see, I will not say it's written, but, it is sort of, they are just not going by a mechanical that, okay, there is, if there is a consumer default so much, and then you immediately, because they are also quite aware of the difficulties in getting a resolution, to this. So that I think deals with the like in real estate companies also, sort of, it is not being so much preferred, and there is a higher threshold of 10% or 100. After that, we have seen not many cases have got admitted, and and also the adjudicating authorities, they're also not they would like to have a resolution instead of going for liquidation. So that is, I think, clearly the object is very much that it should be, they should be able to resolve, okay, not sort of a mechanical admission into insolvency. That is one part. So whatever dues may be there, I think, so that is one part. Other is cross cross border or the disputed one. So as I as I mentioned, as these some of these will have to be dealt with on the case specific basis, and maybe RP or COC will have to look at these whether it is the foreign creditor or somebody. So they will have to look at a different angle and with a different perspective, and which may help in achieving just resolution. So I think, but overall, I think the direction is there from the regulators, from the government, from the courts. I think the broad guidance is available, and within that one can really find out solutions. It cannot be too prescriptive, where for every problem some solution is given or is defined. I think there is enough leeway for RP and COC also to interpret some of the situations which would be beneficial or to find a solution. I will leave it.
Yeah, Shana. So on my brief response to the question on cross-border insolvency and disputed claims is that as far as our existing system is concerned, foreign creditors are treated at par with domestic creditors, right? So therefore, all the issues that we discussed are equally applicable to them. However, if there are foreign proceedings at play, then the first question is, whether our system will recognize those foreign proceedings, and then there is this theory on foreign main and foreign non-main and non-main, etc. And so that becomes an academic debate. And then if you recognize a foreign proceeding as a foreign main proceeding, then you have to see whether this claim that you are considering, will it be considered to be disputed under that law? And if if you recognize it, then how do you deal with it? So I think our cross-border piece is still kind of in a very nascent stage. We don't really have too much practice, 1 or 2 cases here and there. And there is a draft law which is put out for public consultation. I don't know when it's going to actually see the light of the day. But once it comes in, then my assessment is that it will not have too much guidance on disputed claims on or details of claims, etc. It will just have a broad process of what do you do to file a claim, what do you do to make sure that your foreign proceeding gets recognized in India. And similarly, the other way, that how do we make sure that if an Indian claimant needs to claim outside, then I think for that piece, I think even currently, it's possible. For instance, there have been cases where the US ecosystem has recognized IBC proceedings as main proceedings and granted and given some remedies. So conceptually, it's possible that disputed claims here can get admitted there, subject to how their law kind of deals with this issue. But so that's the other way is kind of possible without any change in law. But the recognition of foreign proceedings in India, I think that requires definitely requires a legal change, and let's see what happens in the near future. And on consumer bankruptcy, actually, for me, who advises on policy issues and also kind of is a part-time academic, I see it as a very fascinating issue because there is this very interesting conceptual debate on when, I buy a product and I don't get the product, but the money is still with the seller. Am I a creditor? Do I become a creditor? Theoretically, I don't think so. That's still my money. So he didn't give me the product. So does that make me a creditor? And therefore the reason I said this is because if it's my money, then when the liquidation estate or when the CIRP estate is formed, I should actually be standing on top of everyone else in the scheme of things, because that's my money. That's not part of the CIRP estate. And therefore, as a consumer, I'll argue that I come before everyone else. The moment you start treating me as a creditor, then you will call me an operational creditor or something else, and then I get treated, then I'm at the mercy of the creditor, so to speak. And therefore, I would say that as a consumer, if you look at the current version of the law, it clearly says that the IP will only take possession of assets and monies that belong to the debtor. And I think consumer's money does not belong to the debtor. I'll argue that. And therefore, even today under the law, there is a remedy. And I actually personally felt that this should have been the case for home buyers also. We just had that discussion where home buyers are essentially consumers, right? Supreme Court invented this logic of calling them financial creditors, and the government went ahead with that and gave them statutory recognition. But I personally feel they're just consumers, and that money actually belonged to them, and therefore they should have been treated as superior to all other creditors and dealt with separately, outside the insolvency system. But unfortunately, IBC is seen as a solution to all our problems. So in a way, we see it as folks who have contributed to it as a backhanded compliment, but the reality is it shouldn't be the case. You can't solve all problems with the IBC just because it's working efficiently. Yeah, sorry, maybe I digressed a bit, but that's all I had to say.
No, that makes absolute sense, because insolvency, when you hear, and as we will hear, I think from Robert, is supposed to be the last step, not the first one. Go ahead, Robert.
Okay, just a few comments. One thing I need to say is I just lately was schooled about missionary activities on German insolvency law. One guy, a very, very bright guy who worked for the World Bank and so on and has vast experience worldwide, he told me when I said the German system is so good, he said, well, there are several countries who tried the German system and it didn't work for them. So if you look at foreign systems, if you see something which works there, doesn't necessarily mean it works for you. You have to be sure that it works for your culture, for the history, for your judicial system and everything. You can't just copy. That's what Debanshu mentioned, as it was in India before the new law, obviously. Now with cross-border disputes, just one spontaneous idea I had when I learned of the clean slate principle. I'm very interested in your first case with a big American creditor. There was a big German insolvency proceeding where you treat license contracts differently to how you treat them in the United States. And there was a dispute in the United States where the United States court says, well, in principle, we recognize the insolvency law of where the main proceedings is opened, but in this case, we don't, because it would be detrimental to the American creditor and to the American economy. And that's why we just don't recognize it. And I'm curious how that works out with the clean slate principle, which would not work in Germany at all. I'm totally sure. With consumers, I would have said spontaneously, if I have a contract, I have an entitlement, and if the debtor hasn't fulfilled his entitlement, I'm a creditor. That's the German view. So the consumer in your case, Debanshu, would be a creditor, no question. He doesn't need to claim his right, of course, but if he does, he's a creditor like everybody else. And with regard to consumer insolvency, which is of course a different question, in Germany we use the same proceeding for consumers to get them get to their discharge in the end. but there is an initiative in the EU which might lead to streamlined proceedings, because the motivation of the participants is totally different in those small proceedings. It doesn't make sense for the creditors to invest a lot of activity and then decide on things in consumer insolvencies where you don't get anything anyway. It's just about getting the consumer discharged in the end. And so I think it's not the worst idea to have streamlined proceedings, but it's a good idea to have proceedings for consumers to get out of their debts. So that's from my side.
That's a very positive thought, Robert. Thank you for leaving us with that in a sense. And obviously, it's a fantastic wrap on that positive note. And thank you very much to the panel to actually leave us with a lot of material to write about and a lot of material to think about. And on that note, I want to invite our executive dean, Professor Dr. Satish, to close the ceremony and give us his concluding remarks. Over to you, sir.
Thank you, Ishana. Thank you very much. Dear everyone, good evening. It's a pleasure to see that the first edition of the JGILS Global Law School Insolvency Law Working Paper Series is being successfully concluded. 2 days, 5 sessions, some of the finest minds in the area of insolvency and bankruptcy, and most constructive conversations. Now, this working paper series is in fact a rational choice from the many options we had. Professor Ishana, Professor Indranath Gupta, and I finally decided to go for a working paper series given the openness it has. Although it's not that counts much in the legal publications market. But the working paper series definitely is, or working paper is a new academic culture, a new form of intellectual exchange which creates the proverbial agora. Hence, we decided to get ourselves swayed by epistemic considerations. The need Professor Ishana Tripathi felt deeply about the absence of constructive conversations on insolvency and bankruptcy law eclipsed all other considerations. While theory is a means to turn phenomena into knowledge, knowing phenomena requires a posteriori knowledge in the form of inputs from practitioners. We wanted the self to meet the otherness, thesis to meet its antithesis, and theory to meet the praxis. The real-time conversations around uploaded papers gives the sense of true conversation and dialogue. I'm certain that the records these conversations would leave behind will be the food for thought and inputs for policymaking and decision-making, not discounting their possibility to become journal articles and research monographs, which will have definitely bigger acceptability. I take this opportunity to thank all the authors of the working papers, the speakers, the commentators, and the keynote speakers of this event. I feel truly honored that JGILS has been supported in this venture by the Insolvency and Bankruptcy Board of India, Red Intelligence, and Vidhi Center for Legal Policy. One of the founding members is with us for this session. Thanks to my colleague, Professor Indranath Gupta, Dean of Research at JGILS Global University, for his support and advice. And I must specifically acknowledge the energy and enthusiasm of my colleague, Professor Ishana Tripathi, for her unparalleled deep feelings and passion for insolvency law. That she has chosen JGILS Global Law School as a site for activities like this working paper series. On behalf of JGILS Global Law School, I remain deeply indebted to her. The school and me will continue to support her in all possible ways. Thank you everyone who contributed to this event and series in one way or other. Thank you for those who have connected to us through our YouTube channel. The website and the working paper series is fully operational now, and the call for papers for the next episode will be relayed very soon. So thank you everyone and good night.
Thank you so much for those kind words. Thank you everyone who's joined us on Zoom. Thank you to our last speaker and panel. Thank you to everyone on YouTube. It does take an army, so AV support, thank you for staying with me, and the Research Dean's Administrative Office as well. Thank you so much, everybody. And the call for papers is live now. Thank you to our Executive Dean for launching it. I hope to see you guys in the next sessions, and I hope a lot of you will write for us. Have a good evening, good night, and thank you for staying with us to the end.